We knew it was coming, but now we know how. Trump is back on the ballot, baby. And in related news, a bunch of journalists were not laid off. Yes, Donald Trump gets to stay on the ballot in Colorado's Republican primary. The U.S. Supreme Court reversed the Colorado Supreme Court's ruling that Trump committed insurrection and was therefore barred from holding federal office by Section 3 of the 14th Amendment. The opinion also overruled decisions from Illinois and Maine, ensuring that come November, Trump will foist himself on voters whether they want it or not. But all 9 justices held that the states can't enforce the clause against federal office holders, and then 5 of them went further, holding that the federal candidates and office holders can only be disqualified if Congress passes a law to affirmatively enforce the disqualification clause. And although the headline decision was billed as a unanimous per curiam opinion, it's effectively a 5-4 decision that revealed deep divisions within the court. And as a bonus, it might mean that Congress never disqualifies anyone from committing insurrection ever again. Hey, if the people decide it's time for the reanimated corpse of Jefferson Davis to get a chance to be the Democratic standard bearer in 2032, who are we to argue? Now, Section 3 of the 14th Amendment, as you probably know, was passed after the Civil War, when some of the men who had participated in the Confederacy started running for elective office. Section 3 says that those who have previously sworn an oath to support the Constitution and then engaged in insurrection against it are barred from holding a variety of public offices. The text of the disqualification clause states that this bar can be removed by a 2/3 vote in Congress. And the text of Section 3 reads, "No person shall be senator or representative in Congress or elector of president or vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in an insurrection or rebellion against the same or given aid or comfort to the enemies thereof." But Congress may, by a vote of 2/3 of each house, remove such disability. Okay, so let's acknowledge the obvious here. Though the intent is clear, it's meant to stop insurrectionists from holding office, the text is more than a little cumbersome. And the text doesn't say how the disqualification is supposed to happen. For example, who gets to kick someone off the ballot? Now, much to our chagrin, the United States doesn't have uniform elections laws, and there's a reason for this. The election clause of Election 1, Section 4, gives states the power to regulate the time, place, and manner of holding elections, including for federal offices. Requirements can vary from state to state. In some states, you get early voting for a month, while in other states, you get arrested for giving a person in line a bottle of water.
You're under arrest for violation of the Election Integrity Act.
What? What are you talking about?
It is illegal for anyone in the state of Georgia to provide food or water to voters in line at the polls.
What? That's barbaric.
And states are already empowered to exclude candidates from the ballot if they don't meet the requirements for that office. So if a presidential candidate is not 35 years old, is not a natural-born citizen, or does not meet the state's other ballot regulations, states theoretically can exclude them. Colorado, Maine, and Illinois thought that not participating in an insurrection was another basis on which they could exclude a person from the ballot because it says so in the Constitution. So the first question for the Supreme Court was whether Section 3 of the 14th Amendment was self-executing. A law is self-executing if it doesn't require legislative action or enforcement. Now, other parts of the 14th Amendment are self-executing. And if you look at the historical record, there's evidence supporting the position that Section 3 should have been self-executing too. For example, in 1865, when Congress was trying to ratify the 13th and 14th Amendments, Democrats were openly speculating about drafting Robert E. Lee as a presidential candidate. The Republicans thought it would be disastrous if insurrectionists could come to power. Jefferson Davis and Robert E. Lee were disqualified from holding office, even though they were never tried or convicted of treason or insurrection. And when the government tried to prosecute Davis for treason, he argued that Section 3 was actually self-executing, and therefore the prosecution was blocked by Section 3. And Supreme Court Justice Solomon P. Chase, who we'll hear from again later, agreed with Davis, but Davis was pardoned, so the issue was never resolved. Later, Congress acted to remove the bar on Confederate oath-breaking insurrectionists serving in Congress because why not? What could go wrong? However, there was also evidence in the historical record that Section 3 was not self-executing. Congress passed a few laws after the Civil War disqualifying Confederates from office. That indicates that Congress believed it had the right to enact legislation implementing Section 3. But there's nothing in the Constitution or in the case law saying whether this was the exclusive way that people could be disqualified. That's why the issue of Trump's disqualification was not easy to decide. Now, there wasn't much interest in the disqualification clause between the Civil War and the presidential election of 2020, because as far as we know, presidential candidates weren't really plotting to overthrow the government. But Colorado state laws allow voters to challenge any candidate's legal qualifications for office. So Norma Anderson, a 91-year-old former Republican legislator, sued to keep Trump off the ballot because she claimed that he committed insurrection in 2020.
What is trying to throw out an election? I call it insurrection.
A Colorado district court ruled that Trump engaged in insurrection, as those terms are used in Section 3. However, the district court concluded that the clause did not apply to the president because the presidency is not an office, and therefore the president is not an officer of the United States. The Colorado Supreme Court reversed, holding that Trump was an officer, that he committed insurrection, and that the state had the power to bar him from appearing on the Colorado primary ballot. Maine and Illinois also disqualified Trump on basically the same basis, which is how these cases got before the US Supreme Court. Now, before the US Supreme Court ruled, legal analysts speculated that the justices would want to demonstrate unity by issuing a unanimous opinion rather than a split decision. And that appears that's what they tried to do by labeling the main opinion as a per curiam, which means for the court. This meant to say that the court is speaking as an institution rather than as individual justices, and it's not public who wrote the majority opinion, although it's pretty clear it's Justice Roberts. But this isn't really a per curiam unanimous opinion. Justice Amy Coney Barrett wrote a 2-paragraph concurrence in the result while disagreeing with the majority's reasoning. Justices Sotomayor, Kagan, and Brown-Jackson wrote an opinion concurring only in the result. Their opinion excoriates the majority opinion for going well beyond the issue presented in court. And legal sleuth Mark Joseph Stern quickly uncovered metadata showing that the minority opinion was originally called a dissent by Justice Sotomayor. So first, let's talk about what the justices did not decide. The court did not decide whether Trump's acts fit within the definition of insurrection. During oral argument, Trump's lawyer, Jonathan Mitchell, said it was a riot.
The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection, as that term is used in Section 3.
Now, of course, that sounds bad, but because the court ruled that Colorado didn't have the power to disqualify a federal candidate, the court did not need to rule on this issue. Okay, so let's talk about what they all agreed on. The 9 justices agree that, quote, states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. All 9 Supreme Court justices agree that the states have authority to enforce Section 3 as it applies to candidates for state offices. However, states can't disqualify offices for federal offices. This unanimous part of the decision was telegraphed pretty heavily during oral arguments. Here's Justice Roberts and Kagan during oral argument.
It seems to me you're avoiding the question, which is other states may have different views about what constitutes insurrection. And now you're saying, well, it's all right because somebody, presumably us, are going to decide, well, they said they thought that was an insurrection, but they were wrong.
Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law.
Their point is that if individual states were allowed to disqualify a presidential candidate, then the process of electing a president could be chaotic. Republican attorney generals filed an amicus brief arguing that they would probably disqualify Democratic candidates out of revenge, so this threat is real. A handful of states really could determine the outcome of an election by disqualifying candidates. Of course, this is already the case. America elects its president using a process that no other democracy in the world endorses via the Electoral College rather than the popular vote. And the fact that only a handful of states determine who becomes president is kind of baked in. But the justices are correct that if individual states were allowed to disqualify a presidential candidate, then the process becomes extra chaotic. The court's decision concluded that the 14th Amendment does not explicitly delegate the disqualification authority to the states. Now, arguing if you have to argue to the Supreme Court that you should be on the ballot despite potentially being an insurrectionist, you'll want a good lawyer. But if you want a great lawyer, my firm, the Eagle team, can help. If you've suffered an injury or death in the family, gotten in a car crash, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you get the best representation and find out what your options are. So just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. So click below. The entire purpose of the 14th Amendment was to restrict state power after the Civil War, so it would be incongruous to allow states to disqualify federal candidates. Quote, there is little reason to think that these election clauses implicitly authorize the states to enforce Section 3 against federal office holders and candidates. Granting the states that authority would invert the 14th Amendment's rebalancing of federal and state power. So the court believes, as Justices Roberts and Kagan said at oral argument, that this would result in a patchwork of ballots all across the country, where some candidates appeared on the ballot and some did not. And this is technically true, and potentially worse than the status quo, but we already have a situation where the ballots are not uniform in all 50 states. Some presidential candidates like Robert Kennedy Jr. and Cornel West will only appear in a handful of states. The current electoral process is not exactly immune from post-vote chaos. We witnessed what happened in 2020, and chaos has also at times reigned in the Electoral College. See the elections of 1876 and 1824 if you're bored. And if the decision had stopped there, it would have been pretty much what everyone predicted, an efficient way to preserve the status quo, and it would have been a truly unanimous decision. But the majority went further to address some questions that the other 4 justices said were not before the court. For example, whether its decision applied to offices other than the president, and whether Congress had to pass legislation. Justices Roberts, Thomas, Alito, Gorsuch, and Kavanaugh ruled that only Congress may enforce the Insurrection Clause against federal candidates. Congress can set up a procedure to disqualify someone. Since that procedure does not currently exist, then no one can be disqualified until it does. And if Congress did pass a law disqualifying someone, it would, of course, be subject to the Supreme Court review. So let's talk about what they vehemently disagree with. Justices Sotomayor, Kagan, Jackson, and Barrett agree with the result, but they say that the federalism argument is, quote, enough to resolve this case. Part 2B of the opinion is the only section of the majority opinion that has the approval of more than 5 justices, and that's only because Justice Barrett joined in it. But even Justice Barrett thought that it went too far. Quote, it does not require us to address the complicated question whether federal legislation is the exclusive vehicle through which Section 3 can be enforced. So on the issue of whether the states can enforce Section 3, the majority opinion garnered roughly 5.5 votes, I guess. Now, there haven't been many cases interpreting the Insurrection Clause. As I discussed in my first video on the Colorado case, a Supreme Court justice has only opined on it once. Chief Justice Chase was acting as the Circuit Justice for Virginia in 1869, and in that capacity, Chase decided a case called In re Griffin. In that case, Caesar Griffin had been sentenced to 2 years in prison for assault by a state judge who happened to be a former Confederate officer. Griffin argued that the judge was disqualified under Section 3 and that it was self-executing. Justice Chase disagreed. He held that the legislation by Congress providing for removal was necessary to give effect to the prohibition of Section 3, and without such legislation, the judge was entitled to continue in his position. Although Griffin's case was not a Supreme Court case, the majority in the Trump case found it very persuasive. The majority opinion notes that, quote, Chase went on to explain that to accomplish this ascertainment and ensure effective results, proceedings, evidence, decisions, and enforcement of decisions, more or less formal, are indispensable. Therefore, the Constitution empowers Congress to prescribe how these determinations should be made. Now, this was a different position than Justice Chase had taken the year before in the Jefferson-Davis matter. Chase was Chief Justice of the Supreme Court, but he was also running for president as an anti-slavery Republican who was trying to win the Democratic nomination, which entailed being friendlier to ex-Confederates. Historians say that his decisions as Chief Justice were driven by political expediency, and the liberal justices rejected the holding of Griffin's case, holding it, quote, a non-presidential lower court opinion by a single justice in his capacity as a circuit judge. And they very much disagree on implementing legislation. The majority held that only Congress can implement Section 3, and they must do it by passing legislation pursuant to Section 5 of the 14th Amendment. Congress has passed such legislation before. In 1862, it passed the Confiscation Act of 1862 and the Enforcement Act of 1870. The majority implies that these statutes are no longer in effect, so as of right now, no one can be disqualified. And this opens the door for people who were involved in the January 6th riot to run for federal office, and some of them are planning to do so. And this decision might leave the door open for Couey Griffith, who was convicted of trespassing during the January 6th riot. The New Mexico Supreme Court then disqualified him from running for federal and state office, and Griffith is appealing his disqualification to the Supreme Court in the hopes that the Trump versus Anderson precedent will help his cause. And although New Mexico can arguably still bar him from holding state office, Griffith is hoping that the court's decision will give him a chance to run for Congress. And Justices Sotomayor, Kagan, and Jackson acknowledge that the historical record is mixed, but they accuse the majority of distorting facts. For example, the majority opinion says that Senator Lyman Trumbull, one of the authors of the 14th Amendment, thought that Section 3, quote, provided no means for enforcement in itself. But that wasn't Trumbull's only statement on the issue. Senator Trumbull also said although Congress could pass a law that would provide a, quote, more efficient and speedy remedy for disqualifying a candidate, in his opinion, the 14th Amendment was self-executing. And they disagree about the other clauses of the 14th Amendment. The liberals emphasize that the majority's ruling is inconsistent with how the Supreme Court interprets other clauses of the 14th Amendment. For example, basically all of the other rights secured by the 14th Amendment, like equal protection and freedom from enslavement, don't require Congress to pass legislation in order for them to exist. Quote, similarly, other constitutional rules of disqualification, like the 2-term limit on the presidency, do not require implementing legislation. And perhaps the strongest argument of the dissenting voices is also the simplest. It's the textual argument that since Section 3 says that if the disqualification exists, then Congress can lift it with a 2/3 vote. You can argue that this means that Congress has just one role, and that's lifting the bar. The liberals say that giving Congress the ability to remove the bar by a supermajority doesn't make logical sense if they must first impose the bar by a simple majority by passing legislation in the first place. Quote, Section 3 provides that when an oath-breaking insurrectionist is disqualified, Congress may, by a vote of 2/3 of each house, remove such disability. It's hard to understand why the Constitution would require a congressional supermajority to remove a disqualification if a simple majority could nullify Section 3's operation by repealing or declining to pass implementing legislation. Even petitioner's lawyer acknowledges the tension in Section 3 that the majority's view creates. And while I find this argument persuasive, I think it also hints at some hypocrisy of the liberal justices. Because if Section 3 is self-executing and doesn't require implementing legislation from Congress, then there's no reason for the justices to sign on with the outcome of this case and make it unanimous. It looks like all 9 justices wanted to reach this particular outcome, regardless of how they got there. But the justices do disagree about whether the issue decided was even before the court, and the liberals take issue with the majority's decision to consider questions about what Congress is allowed to do, since that issue was not quite before the court. Quote, although only an individual state's action is at issue here, the majority opines on which federal actors can enforce Section 3 and how they must do so. Their concern is that the majority acted like a legislature. Quote, the majority announces that a disqualification for insurrection can occur only when Congress enacts a particular kind of legislation pursuant to Section 5 of the 14th Amendment. In doing so, the majority shuts the door on other potential means of federal enforcement. We cannot join an opinion that decides momentous and difficult issues unnecessarily, and we therefore concur only in the judgment. Now, there were probably worse ways for this court to make this decision. For example, we can probably be glad that the court did not rule that the president isn't an officer of the United States or that the presidency is not an office under the United States. And there's no text explicitly saying that the states can't disqualify candidates for federal office, but Section 3 is so vague that the court pretty much had to make it up, which is why the 9 ruled that it was just too risky to disqualify Trump. And what's interesting is this ruling on Trump's eligibility has been covered extensively by over 500 news outlets. 29% of the reporting comes from the left and 25% is coming from the right. And if you compare the headlines, you'll start to see some interesting framing emerge. On the left, you have outlets putting constitutional arguments at the forefront, while on the right, news outlets emphasize that the decision was unanimous. These word changes are subtle, but they play a big role in how readers perceive this story. The first set of words might call the ruling more into question, while the second set of words suggests a sweeping victory for Trump. Now, this is all possible thanks to today's sponsor, Ground News. It's so important as we head into the election season because we need to be able to separate the facts from the noise. And they just launched their 2024 election page where you can learn more about the candidates and sort the news coverage by key voting issues. You can see which issues are dominating headlines on a minute-by-minute basis and see specific election-related blind spots to make sure you're not missing out on important stories. Because we all know that this election season is going to be tense, so it's important to find ways to stay grounded and make sense of the chaos. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. Ground News is a fantastic tool for sifting through the daily misinformation and bias. They provide all the tools you need to be a critical thinker, and I cannot recommend them enough. And what's great is that right now they're offering an exclusive 40% off of unlimited access to all Ground News features, including the new election page. And with the sale, the subscription works out to less than $5 a month. Or you can start with their Pro plan, which is less than $1 a month. And you can only access the discount through my link. So click on the link that's on screen right now or down below and get 40% off of Ground News and support the independent news platform working to make the media landscape more transparent. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.